Retirement is an exciting milestone, but it also brings big changes. Have you considered how those changes affect your estate plan? Well, in today's video, I'm sharing the top 5 tips to update your estate plan after retirement so you can protect your legacy and your loved ones. Stick around, these tips are game changers. Hi, I'm Chuck Roulette. I'm an estate and elder law planning attorney licensed to practice in both Florida and Minnesota. And I've helped countless retirees fine tune their estate plans to reflect their new lifestyle and financial goals. If you're retired or planning to retire soon, well, then this video is for you. Now, before we begin, if you haven't already, make sure to hit the like and subscribe buttons so you'll be notified when I post new videos like this one. And if you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. So the first tip is to review your beneficiary designations. So let's start with one of the simplest but most critical and often overlooked updates, and that's your beneficiaries. You want to check your life insurance policies, retirement accounts, and investment accounts. Did you know beneficiary designations actually override the language in your will or trust? That's right. Even if your will or trust says otherwise, your assets will go to whoever's listed as the beneficiary on those accounts. So here's an example. Mary retired and unfortunately forgot to update her life insurance beneficiary. Unfortunately, when she passed, her ex-husband inherited the payout instead of her kids because he was still listed as the beneficiary. A quick review could have prevented that, so double check those names. Tip number 2, reevaluate your will and your trust. Retirement often changes your financial landscape. It's the perfect time to review your will and any trusts you've set up. You want to ask yourself, are your assets being distributed the way you want? Are your executors or trustees still the right choice? For many of the clients I work with, they did that first will or trust 20 odd years ago when they took that first trip without the kids, and it's been sitting in a drawer ever since. Well, now's the right time to pull that out because perhaps your kids, now adults, are the ones that you should be listing as your successor trustees, as your executor under your will, as your healthcare decision makers, your agents under your power of attorney, rather than maybe a sibling or your parents. Have you properly funded your trust to avoid probate? For instance, if you've moved to Florida, updating your trusts is an important step to comply with Florida's laws. Trusts are powerful tools to protect your assets and ensure your wishes are honored. Tip number 3, consider long-term care planning. As we age, the likelihood of needing long-term care increases. Planning for this now can save your assets and ease stress for your family. So some of the options include long-term care insurance to cover assisted living or nursing home costs. Another option is asset protection trust to shield your wealth from being drained by care expenses. I'll quickly share John's story. He had a comfortable nest egg, but unfortunately didn't plan for long-term care. And then a sudden illness required full-time care, and his family had to liquidate assets to cover the costs. However, with proper planning, much of his wealth actually could have been preserved. If you would like to learn more about how to protect your home and savings from long-term care and nursing home costs, I've actually written a guide, Save Our Home, How to Protect Your Home and Life Savings from Long-Term Care and Nursing Home Costs. And you can get your copy by clicking the link in the description below. I'm also hosting an online masterclass where I'll be revealing strategies I use with my private clients and their families to help them protect their home and savings from nursing home costs. And you can join us by clicking the link in the description below to sign up. Tip number 4, you want to update your powers of attorney and healthcare documents. Your durable powers of attorney and healthcare documents are vital. These documents name trusted individuals to make financial or medical decisions if you're incapacitated. Life changes, like a move to Florida or another state, mean you need to ensure these documents comply with local laws. Let's discuss Barbara's case. She moved to Florida and realized her healthcare proxy named her sister, who could no longer serve due to her own health issues. She updated her documents to name her daughter, ensuring she had a reliable advocate. Tip number 5, plan for required minimum distributions. If you have retirement accounts, required minimum distributions are going to start needing to be taken out. And these distributions impact both your income and your estate plan. Now, here's some things to consider to plan effectively. Talk to your financial advisor, your accountant, and your attorney to discuss maybe converting some traditional accounts to Roth IRAs to reduce future tax burdens. You may want to consider using RMDs for charitable giving to lower your taxable income. Integrating required minimum distributions into your plan helps ensure your retirement funds support your goals and smoothly transfer to your heirs. Now, our last point is some special considerations if you're moving to Florida. For many of the families I work with, retirement means becoming either a full-time Florida resident or a Florida snowbird. And if you've recently moved to Florida, congratulations on becoming a resident of a state with no state income or estate tax. But you have to remember the laws are different here. You're going to want to update your homestead declaration and ensure your directives and other planning documents comply with Florida statutes. In particular, you're going to need to update your will and trust to comply with Florida's laws, especially Florida's homestead laws. Also, updating your documents can help prove your residency for tax purposes. Bill and Linda's story comes to mind. As snowbirds splitting time between Minnesota and Florida, they worked with me to align their estate plan with Florida's laws, protecting their assets in both states. If you would like to learn more about the legal requirements for becoming a Florida resident and severing residency up north for tax purposes, you're going to want to get your copy of my book, The Florida Snowbird Guide, a fast and friendly legal guide for Florida relocation and snowbirds. I've posted a link below where you can get your copy from Amazon. I'll also post a link for you to get a free digital copy from my website. Retirement is the perfect time to take control of your plan. And at our firm, we're here to guide you every step of the way. Whether it's updating beneficiaries, planning for long-term care, or navigating the laws in a new state, we can help. To learn more or to schedule a consultation, visit us at roulettelaw.com. And if you want to learn more, I'm going to be hosting a free online masterclass where I reveal strategies I use with my private clients and their families to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And you can join us by clicking the link in the description below to sign up. Thanks for watching. Remember, estate planning isn't about your assets. It's about protecting your loved ones and ensuring your wishes are honored. I look forward to seeing you in an upcoming video or one of the masterclasses. Be well.